Welcome everyone. This is Amer from U-Counsel. In today's lecture, we'll talk about discovery process in a civil proceeding in Ontario. And in this lecture, we will provide you with a very basic overview of what this discovery process is, what kind of principles apply to the discovery process, and some of the rules that apply to discovery process. But the lecture will be quite broad and will provide you with an overview so you can understand the discovery process itself. As always, we will begin with our usual disclaimer that this course and this lecture is not legal advice. If you have any specific questions regarding your issues, you should contact a lawyer or a paralegal or contact the Law Society of Ontario for a referral. Now, a civil proceeding, a civil action can generally be divided into three parts. The first part is pleadings, the second is the discovery, and the third part is the trial part. We have covered pleadings in other lectures, so I would ask you, if you're not familiar with pleadings, to go and look at my other lectures. But briefly speaking, pleadings are documents such as statement of claim, statement of defense, reply, counterclaim, third-party claim, etc. So these are the basic documents that you file and serve, which contain the facts of your case and the legal basis for what you are claiming. So if you are claiming against something, against some party, that will be contained in the statement of claim. You will have all the facts and what is the legal basis for such claim. And in response, the defending party will file their statement of defense. So these documents are the fundamental documents that contain what this case is about, what this action is about, and all of these documents are called pleadings. Now, discovery process, which, as I said, was the second part of the civil action. And what is the discovery process? So let's go through its definition in a bit more detail. It's a pre-trial procedure in a lawsuit where each party can obtain evidence from the other parties. So the key word here is each party and evidence. So each party means if you are a plaintiff or a defendant, then you are entitled to obtain evidence from other parties or a party. If there's only one other party, then you can get evidence from that party. But if there are more than one parties in this action, then you are entitled to obtain evidence from each of those parties. Now, what will constitute evidence? What kind of evidence is provided or is obtained? I want you to keep this in mind. So the evidence should be evidence that is relevant to the issues in litigation. That's the important part. So it has to be relevant to the issues in litigation. Let me give you an example of what could be relevant to the issues in litigation. So let's say you hired a contractor to renovate your kitchen, and the contractor did not do a good job, and you are asking the court to give you damages for the harm that the contractor may have caused you, or for not doing the job properly, but you have some damages because the whole project did not go as it was contracted or as it was planned. So the relevant issues or the relevant evidence would be whether there was a contract between the parties, and if there's a contract, then copy of that contract will be relevant evidence. What was agreed upon orally, that could be relevant evidence. If there were photographs of the kitchen before, after, during the damage, all of those pieces of evidence would be relevant. What would not be relevant is how many kids does the contractor have, or how much money do you make through your living, because those are not relevant issues. The court does not need to know the evidence of those issues to determine whether the contractor did the job properly or not. So the relevant issues are the relevant evidence is the one that is relevant to the very issues before the court, before the judge, to decide the matter. Now, another part that you want to keep in mind, and it's an important one, is that the evidence could be good or bad. Both kinds of evidence need to be produced. So, for example, in this case, while the contractor was doing this job, this renovation, he ended up damaging your television in the living room. And let's say that during this renovation process, he was recording each step of what he was doing, and there is a video that shows that the contractor actually damaged your television set, right? And so contractor has those videos. You don't have copies of those videos, and that part of video or that part of evidence which actually shows that the contractor caused that damage to your television is a pretty damning piece of evidence. Is the contractor allowed to hide that video, to suppress that evidence? No. Even though the evidence could be bad for the contractor's case, the obligation under the rules is still to provide that piece of evidence. So similarly, if you have any piece of evidence that is relevant, but it is not favorable to your case, you are still required to provide that piece of evidence. So it's good or bad. You cannot be selective about what kind of evidence to produce. As long as it is relevant, whether it supports your case or it goes against your case, you are required to produce that evidence. Now, a natural question would arise that why should you provide evidence that is not favorable to your case? I mean, the basic idea behind it may be that we are in a fight. Why should I help the other side's case if I have evidence that goes against my case or that supports the other side's case? And it's a natural question, but the answer to that question lies in the underlying legal principle, which can be phrased in different ways, but one of the ways it is said is that there is no trial by ambush in a civil legal proceeding. So what this means is that there is a fundamental legal principle that our courts, common law courts, believe in, and in a civil system, that is that each party is entitled to know full case and full evidence against it, and each party is required to disclose all of the evidence that it has for its case, so that when the matter goes to trial, there are really no surprises. Both sides or all parties are ready to deal with the evidence that has been presented, and there are no hidden pieces. So you can't walk into a court at the day of trial and provide this damning piece of evidence and say, this is the evidence that will win my case and I never produced it before, because there will be consequences to the late production of that evidence. Now, this is different from a criminal proceeding, and a lot of times our concept of surprise evidence comes from all these criminal shows that we watch, where you notice that someone walks into the courtroom while the trial is going on and approaches the lawyer and provides a piece of paper or a photograph that actually destroys the case of the other side, and that evidence is presented. So a lot of times our concept comes from that, but most of those legal shows or dramas are dealing with criminal matters. And so I want you to clarify that, to be clear, that criminal proceeding is fundamentally different than a civil proceeding. In a criminal proceeding, the Crown or the prosecutor has the burden to show without reasonable doubt whether the person who is accused has committed the offense that he or she is being charged for, right? So in a criminal proceeding, the Crown or the prosecutor has an obligation to disclose all of the evidence that they have against the accused to the accused or to his or her lawyer, but the accused does not have any corresponding obligation to provide any evidence to the Crown, because the burden of proof rests entirely with the Crown. So in a criminal proceeding, accused does not even need to testify if he or she or his lawyer or her lawyer believes that the Crown has no case and they will not be able to establish beyond reasonable doubt that the accused committed what they're alleging that he or she committed. So in some cases, there are cases you will find in criminal proceeding where the accused never even attended and testified at all. Now, one recent example and a famous example of this case is Gian Ghomashi's case, where he was charged with sexual assault and certain sexual misconduct allegations criminally, and at trial, the Ghomashi's lawyer brought forward pieces of evidence which were email correspondence that some of the witnesses who were the alleged victims of Mr. Ghomashi's assault, they had email correspondence which appeared to be quite friendly with Ghomashi even after the alleged incidents of sexual assault had occurred. And these emails were not, even though Ghomashi had those emails and he provided those emails to his lawyer, the lawyer did not have any obligation in the criminal proceeding to provide those emails to Crown. And so when the trial began, Ghomashi's lawyer brought forward those emails and put those emails to the witnesses and basically used those emails or correspondence to doubt the credibility of those witnesses. So very different in a criminal proceeding. What I want you to understand is that it is different in a criminal proceeding, but in a civil proceeding, there are no surprises. You are entitled to know all of the evidence that is against you, and similarly, the other parties are entitled to know the evidence that you have against them. Now, how is the discovery process conducted? First, there is documentary discovery, and then there are oral examinations that are conducted, and in some cases, you can have written examinations. You can also inspect property if one of the relevant issues relates to property, that you are entitled to inspect certain property. And then in some cases, medical examination of a party may also be part of the discovery process. Documentary discovery, which is generally one of the most important aspects of discovery, except for the examinations, you are required to provide all documents, and documents includes data and information in an electronic format. So what this means is if you have any paper trail, paper copies, you're required to produce those. If you have any emails, letters, text messages, photographs, videos, audio recordings, etc., all of these are required to be produced. Now, the word document is actually defined in the rules of civil procedure, and you can see it here. A document includes data and information in an electronic form, and an electronic includes created, recorded, transmitted, or stored in digital form, or in other intangible form by electronic, magnetic, or optical means, or by any other means that has capabilities of creation, recording, transmission, or storage similar to those means, and electronically has a corresponding meaning. So it's a very broad definition of document, and it includes all kinds of evidence, and you want to make sure that all those kind of evidence are produced. And with respect to electronic evidence, I want you to keep in mind that the obligation to produce is the actual electronic copy of the electronic evidence, not just a printed copy. So for example, if you have emails, the obligation is to provide the email in its electronic format and not just print it and provide it to the other side. Although generally speaking, if there are no issues with respect to how the data is stored and how it is created, then most counsel or most parties are okay to receive the content of the email in a printed format. Oral examinations, it is an examination of a party under oath. It is recorded and transcribed, and it is used at trial. So the oral examination it does not happen in court. It happens outside of court. There are private companies which are called court reporters. They have these facilities which you book, and they have rooms and a court reporter. You swear an oath, and your examination is recorded. The other party asks you questions, or their lawyer asks you questions, and similarly, you can ask them questions. It is all scheduled beforehand, and then the examination is conducted. And all of this examination, because it is under oath, the evidence that you provide at oral examination for discovery is used and can be used at trial. So this evidence is as good as evidence given at trial. And so there's a significant importance to the oral examinations for discovery. So some of the procedural aspects of discovery that I want you to understand, obviously, the most important part is rules of civil procedure, which provide specific rules with respect to the conduct of discovery, and these rules are 29.1.01 to 33.08. I will encourage you, if you're going towards the discovery process, to review these rules very carefully. Each rule has significant importance, and I will try to cover specific rules in ongoing lectures. I'm not going through these rules in this lecture because it will be a very long lecture, and it will be cumbersome to cover all aspects of it. But we will cover specific rules later on in further lectures. Just so that you understand broadly, the way the rules define the discovery process is that once the pleadings are closed, meaning that every party has filed their reply and defense and statement of claim and whatnot, then within 60 days, parties have to agree to a discovery plan. And discovery plan is generally, you agree to certain dates. When will we exchange documents? When will we conduct examinations for discovery? On what dates? If there are potential motions for undertakings and refusals, and whatnot that arise from an examination from discovery. What are the dates for that? So it's a discovery plan is sort of a plan agreed between parties. It could be very brief, it could be very elaborate, but it outlines some of the dates when certain steps for discovery need to take place. Once the pleadings are closed, you also have an obligation to prepare affidavit of documents and serve it on the other side. Affidavit of documents are essentially your affidavit that states that I have gone through all my records and everything, and I believe these are all the documents that I believe are relevant to the issues in this action, and I'm giving these to you, and you receive affidavit of documents from the other side. So those are the documentary disclosure that is conducted through affidavit of documents. And then you once you have the affidavit of documents, you have oral examinations scheduled where you examine the other side and they examine you. Value of discovery. Discovery is one of the most important steps before trial, and I think it is important to understand that the value of discovery and some of the things that discovery can allow you to do. Number one, it enables the parties to assess the strengths and weaknesses of their case, and this point is important. When I can tell you from my experience, when we have conducted examinations for discovery, at the end of examination for discovery, at least the lawyers who are reviewing the case objectively for their client and reviewing the case objectively for the other side, they have a very good sense of the merits of the case in terms of the ability to succeed based on the evidence that is before them. So after the examination for discovery is completed, generally lawyers have a very good sense and they can advise their clients, generally speaking, not in all cases, but generally speaking, what are the strengths and weaknesses of that case. And once you are clear about the strengths and weaknesses of your case, then it helps you to, number one, narrow down the issues for trial. So let's say you have thought about 5 different issues when you filed your pleadings and you thought all of those issues were important. But once you have conducted the examination for discovery, you may realize that not all of the issues are important, only 2 issues are important, and you can actually narrow down the issues so you can focus on those issues at trial. Examinations for discovery and discovery process also help parties reach a settlement because now all the evidence is on the table. You have seen all the documentary evidence. You have seen all the stuff that the other side has in support of their case, against your case, in favor of your case. They have seen yours. You have examined the other side. They have examined you. So there's not much left other than the actual trial where you allow the judge to determine who is right and who is wrong. But prior to that, if you would like to reach a settlement, you have a very good sense of the strengths of your case, and then it allows parties to be reasonable and agree to a settlement. It also makes the trial process more efficient and fair because now you have narrowed down the evidence, you have narrowed down the issues, and you have a clear sense of what the evidence is going to be at trial. So it makes the process a lot more faster, more efficient, and fair. So in conclusion, you want to keep in mind that discovery process is actually one of the most important process in this process before trial. You want to carefully review all of the rules that apply in discovery process, and you thoroughly prepare for the examination. Why? Because you want to keep in mind that over 90% of cases in Ontario, civil cases, actually do not go to trial. They settle prior to trial. So if you have conducted an effective examination for discovery and you have shown to the other side through your examinations and documents that you have a stronger case, then your ability to get a better settlement is much higher. Thank you for watching. I will try to cover different aspects of discovery process separately in the following lectures. If you have any questions or comments, please feel free to contact us, and we look forward to seeing you in the next lecture.